failing to pay child support, that the maximum penalty you could face would be up to 45 days in jail. Do you understand that?
I'd rather wait for a lawyer, please.
Okay, I'm not asking whether you agree with that. I'm just asking whether you understand that that's the penalty you could face if you're found guilty of contempt for failing to pay child support.
I'm going to wait for a lawyer, if you don't mind, Your Honor. I'm not trying to be disrespectful at all.
Are you saying you don't understand what the maximum penalty is?
No, I need someone to explain it to me.
What don't you understand about the possibility that you could face up to 45 days in jail if you're found guilty? What don't you understand about that?
I'll wait for a lawyer, please.
All right, you're not subjecting yourself to any criminal penalties by saying whether or not you understand the maximum possible penalty. So you don't have the right to remain silent on that question. Do you understand that or don't you?
I understand, but I'd rather just have some representation for me before I continue.
I get that. I understand that, okay? And I'm not going to make you make any statements on the record here today that could expose you to criminal liability. But it's my job to make sure that you understand what your rights are. You get that?
Yes.
Trying to make sure that you understand what your rights are and what you could face. I'm not trying to get you to say something that's going to hurt you. Do you understand that you have the right to have a lawyer and that if you couldn't afford one, one would be appointed for you at public expense? You also have the right. You also have the right to represent yourself. Do you understand those rights?
Yes.
Are you going to hire your own lawyer? Did you want to see if you qualify for a court-appointed lawyer?
Court appointed, because I don't live in Michigan, so I need it'd be too expensive. I can't afford it.
Okay, so I'm going to refer you to an attorney named Gary Gilo. He's our court-appointed program administrator. He's going to review your case to determine whether or not you qualify for a court-appointed lawyer. If you do qualify, then he'll appoint a lawyer for you and you'll be informed of who that is. When his office contacts you to make that determination, that you need to cooperate with them, and if you want to have a court-appointed lawyer, and provide the information that they need to make that determination. If you don't supply that information to them, then you just won't qualify. Do you understand that?
I just don't understand why. I've been honest with my son's mom and honest with the friends of the court, and I started a new job that I really like, and I make a decent amount of money, and I was just going to start paying it back. I don't get why I'm in trouble.
It sounds like because you haven't made any payments since April of 2022.
I was unemployed. I'm sorry. Right. I didn't mean to sound brash.
Something's happened.
I'm sorry.
Something's gone on since April of 22, and we'll get it straightened out. And if you have a reasonable reason for not paying, then you won't be in trouble. If you don't, then you might.
Sorry if I sound brash. I just, it's very, very frustrating.
So the court will set this for a hearing. You'll be notified of the date and time of that hearing by the court. And you'll be contacted again by Mr. Gilo's office for a determination. It's important that you follow up with that contact, okay?
Yeah, that's fine. I have no choice, right?
You have lots of choices, and Mr. Gilo, will be able to advise you on that as your lawyer.
Yeah, he looks like he's 12 years old.
So first of all, that's not Mr. Gilo, that's Mr. Brzezinski. And
I know. I understand. I understand.
Certainly by personally insulting people involved in the process, you're not going to help yourself.
I'm just, Your Honor, I apologize. I'm frustrated. I've been trying to fix this for months and months and months.
from here. But again, insulting people involved in the case is probably not going to help your cause. So you can find a way to deal with your frustrations. We'll see if we can get this figured out.
All right, Your Honor. Thank you.
That's all for this hearing today. Again, look for the notice of the date and time of the next hearing in the mail, and you're free to disconnect.
Hey, I'm sorry I said that about you. I apologize.
Oh, could you please repeat that?
Could you please state your name, sir?
Yes, my name is Gary Randolph.
Good morning, sir.
Thank you. Good enough, come on. Just we're here for a pretrial, and there also is a bond violation report from community correction. Those two items, I think.
That is correct, Mr. So first, let me arraign him on the bond violation. Sir, you're here on a bond violation. It alleges that you violate the terms of your bond because you've tested positive for THC every time you've tested, and you've missed 2 tests on October 4th and September 18th. So therefore, if it is found that you are in violation of your bond could be revoked. And you're entitled to have a hearing to make that determination if you admit to or you are found to be in violation. What would your client like to do, Mr. Dowse?
Well, Mr. Randall maintains that he has not been using marijuana while on bond, that he was a chronic heavy user until his arraignment, and that he will be testing clean of THC in the next few weeks. That being his position, I would ask the court to give him those few weeks, put it over, and then see if he tests clean.
Ms. McDuffie?
Your Honor, Mr. Dawson, I had an opportunity to catch up in some detail, I think just prior to last weekend. My issue and my concern with this, obviously THC is not the most dangerous drug out there, but it is still a condition of the court that he not use it. My overriding concern is that I had the opportunity to witness or watch Mr. Randolph's arraignment. And at that time, when he was instructed about not using marijuana, alcohol, or illegal drugs, he smiled and looked up and said, if I want to smoke, do I need a medical marijuana card so I can do that? So I think there was an indication right up front about his intent to kind of do what he wanted, or to try to figure out how to. So I can appreciate that he, I think, has been admonished by his counsel and is planning to now adhere to the court's orders. But we have had a number of violations since that arraignment, and I just don't believe it should have taken quite this long for him to get that message. So I would ask that I don't know what's required to, if the defendant has to initiate that testing to see what the actual levels are and if they're going down, and how much time it takes for THC to clear from one system. We shouldn't have to do that at all, but I would request that that is done, because I don't think there should be any more excuses, especially after this.
Any response?
I'm not in a position to disagree much with what Ms. McDuffie says. It's outside of my experience that someone would still be testing positive 10 weeks after arraignment. Is it impossible? I don't know. Would it be helpful to have a lab analysis of Mr. Randolph's results? Yes, it would be. I think that's a reasonable step to take.
Thank you. So at this point, I'm going to interpret the responses as this. You're requesting that we have a hearing in this matter, which I'll schedule out for November 27th. At that time, we will have a hearing if it is necessary. You need to reach out to Ms. McDuffie at least a week beforehand to let her know whether you're going to be having an official hearing or not. By that time, he should be testing negative. If he's not testing negative, then I'll know that he has no intent to follow this court's orders. I agree with Ms. McDuffie's assessment that typically it takes about 30 to 45 days for it to get out of your system. We're right at that borderline right now. So if it is still testing positive, by the time we get back here, then he did not stop smoking when he was supposed to. So that's how I will handle it at this time. As to the pretrial.
On that end, Judge, we are still, Ms. McDuffie and I, still looking to review a final piece of discovery and then have a discussion of merits and resolution, and would ask to put the pretrial over for that purpose.
We can put them both over to the November 27th date.
Yes, please. Would it be at 9 o'clock?
I'm sorry?
Would it be at 9 o'clock?
It'll be at 11 o'clock and in person, unless he's not testing positive, and then you two can talk about that between that time and now. But at this point, it's going to be in person.
Very good.
So, Ms. McDuffie, if you approve that it be via Zoom, then I will agree to that.
Okay, sounds good.
Thank you all around.
Thank you. See you then.
Good day.
You too. Bond is continued. So we'll call the matters of Brian Holly, case numbers 21S00163, 21T00282, 22S00523, and 23S00528.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Holly, who appears via Zoom from the jail. Mr. Holly, can you please state your name for the record?
Yes, Brian Idell Holly.
Good morning, Mr. Holly. Good morning, Mr. Burnett and Mr. Bellinger.
Good morning.
Good morning, Your Honor.
Your Honor,
Go ahead.
it's my understanding we're here for pre-trials this morning. I made a late discovery, unfortunately, that we didn't have the correct discovery for the telecommunication services case. When I'd spoken with Mr. Holly, we'd been talking about global resolutions. We hadn't looked at that case in particular. I have made the request to get that corrected this morning, and that is being sent over, is my understanding, so that we can review that. So we would be asking for an adjournment on these matters. This would allow for more conversation, hopefully for a global resolution, and I would ask to address bond at the appropriate time as well.
You may at this time.
Thank you. Mr. Holly is in on a $25,000 bond. He's been in for some time now. He has some pretty heavy family stuff going on right now. We would be asking for the court's consideration for a GPS tether in lieu of him remaining in jail. He would like to get out. He'd like to start working. He'd like to be able to prove to the court that he's capable of being out without absconding. He understands that the court considers him to be a flight risk, considering the 2 years that went by where he was absconding. That said, it has been a minute now that he's been in jail. He does take these matters very seriously, and he does wish to remain and challenge them. He's been in this community for 20 years in this general location, and so he's not going anywhere.
Thank you, Mr. Burnett.
Your Honor, I leave it in your discretion ultimately, but this is a rather old case. I believe he didn't appear at a final settlement conference. The allegations in the case are that there was a crash and a blood alcohol level of 0.221.
Thank you.
And Your Honor, if I may respond on behalf of the state.
You may.
As Your Honor called, Mr. Holly is here on 4 cases. 2 of those are the older ones, which are the child abuse case from the state, as well as the high VAC case from Mr. Barnett that he just discussed. When Mr. Holly absconded, it was a combination of him not testing, or I believe after testing positive, but not testing at all, as well as not showing up. The subsequent 2 cases that we have from Mr. Holly are another child abuse related allegation, as well as malicious use of telecommunications with Ms. Christine Hickman, mother of those children. The last time we were here at the pretrial, I mentioned that Mr. Holly had made some calls from jail, specifically instructing Ms. Hickman not to come to court and participate. And she apparently changed her mind about what she plans to do. even regardless of her intentions for planning to come to court after that conversation. I did indicate that I would be looking further into that to find out if there was enough to substantiate a felony charge, and I would certainly be proceeding with that if there was. Mr. Holly has continued to contact the people he's not supposed to have contact with after that hearing. In fact, discussing on one of those calls the fact that we brought this up in court and that I heard those calls previously. Mr. Holly currently has a no contact order with Ms. Hickman and with all of the children, given that there are direct allegations involving each one of those parties. He has since spoken to them, and also had a call with another individual where he made it very plain that he was not going to not only plead to anything, which he certainly has a right. Mr. Holly can exercise his full rights to have a jury trial on each one of these four cases. But he mentioned that he was not pleading to anything, and he was not going to be on anybody's tether whatsoever. He said that he was going to leave that jail with nothing. He was going to stop drinking if he decided to do so on his own terms. So given the fact that there are continuous bond violations that not only reflect upon no contact orders, and the fact that Mr. Holly, I understand, is eager to get back to his family and work out his problems on his own terms, but right now, the allegations are against every member of that family, and we're still violating no contact orders. Alcohol is an issue in each one of these cases as well. I don't see why continuous violations of bond would merit any sort of favors in a release to continue doing so. I don't know what has been provided to the court or to the people or to Mr. Barnett that would be any reassurance that all of this is going to change if we reward that behavior.
Thank you.
You
Anyway.
can I say something?
You may not. I think you said enough in your phone calls, don't you?
I just would like to say that it's imperative, Your Honor. I'm just concerned about my children. The case with my son, he's now locked up in a juvenile facility across the street, Your Honor. He was caught with a loaded gun. I apologize. I know I went against the code of the court, and I'm truly sorry about that. But one thing I would like to make the court aware of is that I love my children, Your Honor, and I'm scared for him. I'm scared for my children. I know I made mistakes, and I'm here not to go against nothing you guys are saying. I'm here specifically to take accountability for what I have done. The reason I have talked to my children, to talk to her mother, is strictly based on caring and being concerned about them. I've been in here 31 days, Your Honor. I've had no sleep. I've been very stressed about and worrying about my child. Now the situation that happened, I'm not gonna go too far in detail because I know this is not the time. Parent tells child to do right in school. Listen to the teacher. Do what you're supposed to. Don't get in trouble. The reply he says is, F you, I do what I want. I say, give me your phone. Go in your room. He goes to the room. He gets another phone. He calls the police.
All right, Mr. Holly, you're treading here. Be careful.
I'm just trying to
I know.
I'm gonna make this short because she's giving me an opportunity to speak.
Actually, I didn't. You did exactly what I said.
I'm sorry, ma'am. I'm hearing all this and it hurts. It hurts to even hear these allegations put on me. I'm a parent and I know I have not made all the corrective choices, but I just want the court to know. I just want the court to know that it sounds bad, but I love my children. I will never hurt them. I'm just guilty of not knowing what to do at times. I'm a hardworking citizen. I've been around this county for 20 years. I work. I do what I'm supposed to do. I have not committed any atrocities in terms of crimes. I've made mistakes. Your Honor, and I'm accepting accountability for that. I promise you I am. But what I'm not is a threat to society. I'm not a threat to the world, and I'm definitely not a threat to my children. But what I do know is that my son was just put in a juvenile facility. He's on probation, Your Honor. He has a GPS teller on his leg right now. He's only 13. He was just caught with a loaded pistol. This is what I was trying to prevent. And in doing so, I was lied on and said that I
Okay, Mr. Holly, careful, you're treading here again.
Okay, I'm done. I'm sorry, Your Honor. I'm sorry. I just feel these allegations is making me look brutally bad when I know I made mistakes. I'm taking accountability for this. But I promise you, I just want to be out to do a better job in raising my children so I can move on in my life. I would accept any stipulation that the prosecutor agreed to, a teller, alcohol monitor, anything, and I will abide by that. And I promise you I will. I just feel like I have such more duties out there than I do in here. And I know I'm a contribute to the world, not being in here. And I just want an opportunity to prove that. And if you guys can just give me another chance, I promise you I will abide by any stipulation that's given by the court.
Sir, all you've proven to me so far is you will not follow any of my orders or directions at all. I told you not to speak, and now you've been speaking for about
I'm sorry.
maybe 7 to 8 minutes. I told you not to make any additional phone calls. You did that. I told you to show up for court. You didn't do that. So pretty much everything I've ordered you to do, you've done the opposite of it. And you sit here telling me that you haven't done anything, when in fact you're before this court on 4 separate cases, including one, which is drinking and driving involving a crash. Bond request is denied.
Thank you, Your Honor.
What date would you like to come back? Either November 13th, November 20th?
I think November 20th or November 13th would be best, Your Honor.
You're gonna be ready in a week?
I can be ready in a week. We expect to get that that discovery sometime in the next couple of days, and I will review that with them, and then we will either set these for trial or seek to resolve.
And I'm going to trial, bro. Not pleading guilty to none of this. It's all absurd.
Well,
And
we
y'all
can certainly
not find me guilty. Y'all wasting taxpayers' money. I don't care
Your
what.
Honor, we can certainly set these for jury trial at this time. It would still give us time to review the new discovery. If we want to set it for a final settlement conference, it might be best at this point.
Your Honor,
Yes.
I'm sorry, no objection to that. I just wanted to bring up, the court mentioned that also with the last pretrial. Mr. Holly seems to be fixated on one of these cases in particular. The earliest case is a child abuse case involving Miss Sierra Holly, who actually did appear for the final settlement conference. Mr. Bellinger, I hope you have full discovery on that, including the supplemental reports with the photos of her in the hospital and all the CPF attachments that go with that. So, so we would not be needing to produce her, as well as the fact that she is a minor in the child abuse case, and she would need to be produced for trial by the adult that currently has the care of her. So this will not be a case of somebody not showing up.
On December the 16th, 2021, it looks like the witness Sierra Holly was present and excused for future dates. So she does not need to be present. I wrote that in my notes myself.
Okay.
So that one will be going to trial definitively.
I will be found not guilty. Innocent until proven guilty.
All right, Mr. Holly, please be
Innocent until proven guilty.
understood.
Sir, if you keep speaking out, then I'm going to hold you in contempt of court. Any contempt will be run consecutive to any time you have to do. Do you understand?
Yes.
November 16th, 2023 at 9 a.m. for final settlement conference. And December 1st. I'm sorry, that should be 11 a.m. for the final settlement conference. December 1st, 2023 at 9 a.m. for the jury selection. The defendant needs to have proper clothing so that he appears appropriately before the jury on that date. So please make sure that he is prepared for that date.
Okay.
And Your Honor, I will be submitting an amended complaint. There is an error on the case that Mr. Holly is so fixated on with his older son, I believe. And so I was just incorporating, I was going to dismiss that case with the global resolution, but since we're going to proceed on it, I do need to make a change to it. So I will submit that to the court ASAP.
Please submit it as soon as possible so that they can be prepared for the trial.
Will do.
Thank you. You're all set, Mr. Holly. I see you on November 16th. State of Michigan versus Denali.
We now call two cases, 23 CR 188 and 189. The state of Texas versus Jamarius Spraggins. These are attempted aggravated assaults with a deadly weapon, a third-degree felony on each case. That's you, sir?
Yes, sir.
Here with your attorney, Mr. West, and the state's attorney. All right. I see the plan is the defendant is going to be pleading guilty to 188. No, it's on both cases?
Yes, sir.
Is that right?
Yes, sir.
Yeah. It's only 188 is the only one that's on the docket, but I guess that was just a mistake.
We're gonna run CC. That's the.
Yes. All right. So there are actually two cases before the court, 188 and 189. Looks like earlier in these cases, the defendant had pleaded guilty to these third-degree felonies. Pre-sentence reports have been prepared. If the parties had an opportunity to review it, any corrections or changes to them?
No, not mistake.
They're made a part of the record for all purposes. The agreement in each case, a cap of 10 years confinement, though, to run concurrently.
Yes.
So he's looking at up no less than 2 nor more than 10 years confinement, but whatever sentence the court assesses, the cases shall run concurrently with each other. So go ahead. A defense may go first.
Your Honor, the two big issues I want to point out on this case or at the court, we'd like the court to take into consideration.
Yeah.
One is my client's taking responsibility for this and pled guilty and is accepting responsibility for his involvement in this matter. The second thing is his age, Your Honor. He is young. He is before he was arrested, he was in high school. I mean, I guess he's still in high school, but it depends on what happens here today, obviously, because if he is sent to prison, then he'll have to do a GED later. But we think it's a situation where, from talking to him and kind of getting an idea of what's going on here, Your Honor, is that he was kind of caught up with the wrong people, the wrong place, the wrong situation, just everything in a bad situation. And he's asking the court to give him a chance. The court could, in this case, give him deferred probation if the court determines that's right for him in society. We believe it is. We believe that due to his age and his the situation, we would request the court to consider probation in this case. It's one of those things, if we send him off to prison, what's it really going to do? It's going to lock him away for up to 10 years, and then he's back, and there's nothing's really changed his life. However, I believe he's young enough that we can make a difference, or the state can make a difference in his life. Put him on probation, get him some guidance, make sure he stays on the right track. And if he doesn't, then he's off to prison. It's on him. But at least give him a chance to try to do what's right and to make up for this and make him a better life and do better for himself.
Okay.
Judge, he got the biggest break in the world by being charged with what he's charged with, because he was a party to a murder and an aggravated assault. And just because his gun did not fire, he gets a break of what the grand jury decided to indict him on after being presented by our office. But there was somebody killed and another person injured, he lost his life, his livelihood, his job, everything, because of the injuries he sustained as the other victim. So what would be accomplished by putting him in prison for 10 years? Justice for the victims, one that was murdered, one that was shot. I mean, these people came from another county over to a party, and they brought a whole busload full of guns and ended up shooting and killing one individual and wounding another. And the only reason that Mr. Spraggins wasn't charged with the murder was because his gun jammed. And otherwise, he might have been the one that actually fired the deadly shot that killed him. It was shooting. It wasn't like he wasn't pointing at his shooting. So we would ask for the 10 years on both cases. Anything else?
Your Honor, again, and I'm not going to minimize the offense, because that's it was a very serious offense. But I am going to point out the fact, like I said, that's why I started my arguments with it. Wrong place, wrong time, wrong people. He was in a bad situation with some bad people doing bad things. And that's where I'm getting at, Your Honor, that putting him on probation and giving him the guidance and making sure he stays away from bad people, bad places. We put him in prison. Yeah, there's justice. But then in at most 10 years, he's out or less or whatever the government decides to keep him in. And then he's back to the same actions. And this is something where we might see him again in 12, 13, 14, 15 years and over again. Whereas the court has a chance right now to divert that and maybe say, look, I'm going to give you a chance. You're young, was stupid, whatever you want to say. Put him on that probation, get him that guidance, and make sure he lives the straight and narrow for the next 10 years, however long the court wants to keep him on probation, to make sure he does everything he's supposed to do. And then maybe in 10, 12, 15 years, we don't see him again because he's had that guidance, had that help. And that's my argument. I know the state has a different argument, but that's our position.
Anything else you'd like to answer? Anything you want to add?
Yes, sir.
Mhm.
Speak real. Just like I told my attorney, I was at the wrong place at the wrong time. I was intoxicated. I didn't know what was going on. I just heard it was a lot of commotion. So me going my first mind being intoxicated is all out. But I ain't planning on hurting nobody, because if I did, I would have did it, but I stopped myself from hurting somebody that night. I got a son, birthday today.
How old was your son?
He just turned 3. And I'm just trying to get home to him.
Anything else? No,
sir.
Let me just take a moment to respond to a couple of things you've said.
Yes, sir.
Number one, intoxication is not a defense.
I already know, sir.
You brought it up. Let me speak.
Yes, sir.
You brought it up. For whatever point it was, voluntary intoxication is not a defense. Whatever you do while you were voluntarily intoxicated, you have to accept responsibility for. Number next, hanging out with these people, you knew better. You made a choice. Number last, which is the worst thing. You throw your child in front of this court and try to hide behind your child. Oh, yes, I've got a child. At 2:30 in the morning when this was happening and you were trying to shoot and this guy almost got killed, your child was at home somewhere asleep. Why weren't you being the father you were supposed to be? If you were, you wouldn't have been out there. You wouldn't be in here today. But here you are trying to express your concern for your child. You had a responsibility at that time, which you neglected. Let me read this from the victim. He doesn't think a 10-year prison sentence is sufficient. This man believes it was God's will that he didn't get killed because it was a matter of luck or providence that he wasn't shot and killed. And if you would have been able to fire the gun, it would have probably been fatal. That's what he says. Far too often in this court, we see the same old thing. People with foolish decisions. Later on, they try to explain them away. This is such simple stuff. Who points a gun at another human being and fires it or tries to fire it? When you got responsibilities at 2:30 in the morning, you're out there frolicking and having fun with guns. People's lives are in danger. Your responsibilities, your children are at home sleeping where you should have been taking care of them, and this wouldn't have happened. I mean, how many things do I have to check off that you did wrong here? But that's typical that comes into this court, this kind of behavior. And it's wrong. It's irresponsible. And it is going to cost you. I just wish you would have acted more responsibly. I'm going to find in each of these cases, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in 23 CR 188. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. In 23 CR 189, I'm going to place you on deferred or unadjudicated probation for 10 years to run concurrently with this crime. You are ordered as a condition of probation to pay restitution in the amount of $16,500 to Armando Camargo Jr., the victim in this case. If you fail to do that, your probation can be revoked and you can be sentenced up to 10 years in prison. In the 188 case, the judgment will reflect that a deadly weapon, namely a firearm, was used in the commission of that offense, which means you're not going to be paroled until 50%, 4 years or served, and you're going to be on probation. At the same time, you will be released, put on probation, and I expect you to pay this poor man back for the horror you had to put him through. You understand what's happened today?
Yes.
You're talking about responsibilities. Well, we'll see how you handle this responsibility. Do you understand?
Yes, sir. Judge, please, can I have a moment with you, sir?
No, sir. Yeah, no, you can speak, but you don't have a moment with me alone. No. What did you want to say?
I would just, could have been worse. Thank you for doing that for me, sir.
You got a family. I mean, your life touches other people's lives. You acted selfish. You acted as though no one else existed. No one depended upon you like your child, your family. They do. All you're doing, like so many people in this courtroom, is just thinking of your selfish needs and whims. And here you are. You're no longer free. You've lost that. Someone almost got killed. Good luck with that on your soul if you have to deal with the intentional taking of a life. That's a terrible thing. But I want you to, when you are released, you pay back this restitution for this poor man.
Yes, sir.
You make some small part to try to fix this mess that you've gotten yourself and your family into. Anything else? That is all. John, you've got.
On Mondays, we have trial cases, and then people will come back on Tuesday. And on Tuesday, that's when we actually do jury selection. So this is the last time for people to talk, maybe make sure that everybody has their discovery the way they're supposed to have it. So that's what it is. And then we have people in the back. And so the inmates, they're brought over in, of course, their uniforms that they give them at the jail. But when it's their time for jury trial, they'll be brought over in civilian clothing, and they'll be brought over in whatever clothing they were arrested in. That's why if you're a defense attorney, you need to always watch videos. There was one incident and there was case law on it. A defendant was brought over. He was charged with robbery or something. And he sat during the jury trial with the clothes on that he's alleged to have committed the robbery in. And so it's always important that you figure out what your client is wearing and what clothing they have at the jail. And you usually should do that. Don't do it months in advance, because if you do the clothing exchange months in advance, that clothing's going to get lost or somebody's going to take it or some other defendant's going to end up with it, then you're going to have to try to do it again. With the clothing exchange, sometimes your client will have family who will say, don't worry about it. We have the clothing, and you'll know which family members are dependable to do that. Because sometimes you'll have people who say, oh, we're going to do the clothing exchange, and they don't. And then you're scrambling to get clothes for your client. And when you're a defense attorney and you're appointed and you get clothes for your client, the court will approve you to spend your money to get clothes for your client, but they have a set fee. Me, I would go by their set fee and the rest of it would end up coming out of my pocket because I would either go to JCPenney, and I tried going to Walmart once. Walmart prices were just as high as JCPenney because when you think about it, you got to get them pants, you got to get them a top, you got to get them a tie. They don't allow belts anymore, but when I first started practicing, you would have to get them a belt. You'd have to get them socks. You have to get them shoes because you don't want them coming over in those flip-flops because people will notice their feet, right? So you have to do all of that. And then the other thing is I would always try to make sure my client was able to get a haircut. They do have where you can get a haircut at the jail, but it takes a lot of wrangling to do that. And so I would do that and make sure they were dressed appropriately for court. Because the last thing, you don't want your client appearing in a ratty t-shirt because regardless of what people say, sometimes people hold it against you the way you're dressed. And I would always tell my clients, look, we want the jurors to listen to your story if you're going to testify. So you got to give them a book that they're interested in reading. If the cover doesn't look good, they're not going to read it. And so I've had young clients before too. And I remember I had this young client and I'm like, you need to be dressed appropriately for court. He's like, I'm not trying to impress anybody. I said, you're looking at life in prison. You better try to impress people. Your friends and your family members are not going to be on the jury. And people always talk about jury of your peers. Honestly, you are not normally going to get people from your neighborhood on the jury. If you're 18 and you're in felony court, you're not going to get 18-year-olds on the jury because usually maybe they're in college or maybe they're in school. That's the excuse for them not to be on the jury. So you're not going to have that. Derek Reyes.